Welcome to Probate Weekly. I'm Bill Gross, at Bill Gross Probate on social media. We get together every week and talk about both probate, which is if things aren't done properly, and avoiding probate through proper estate planning. We're excited today to have somebody we've interviewed before on the channel, and first time on our episode, Your Belinda, California, which is North OC, Josh Ramirez. Josh, thanks so much for coming back to us.
Thanks for having me, Bill.
You know, I know in particular one of the hot topics, because we both are here in California and in Southern California where real estate is so expensive. Recent changes, Prop 1319, have really gotten people's attention as far as the tax strategies, as far as selling, not selling. If we plan it right, we won't get stuck with a big bill. Talk a little bit about the changes and what smart people are doing to avoid a big tax bill, or what the consequences are if you don't.
Yeah, thanks, Bill. So in our consultations, everybody calls us and says, trust. Let's do a trust, equal to my kids. And we bring up Proposition 13 and Proposition 19, and people are shocked by what this is. So let's start with Proposition 13. We've all heard it. We have a general idea what it is, but just to kind of educate the listeners here, since the 70s, we've had Prop 13. Prop 13 says whatever you bought your house at in the 1970 value is at the earliest, we're going to keep your property tax bill the same. It goes up a couple percent a year just with inflation, but your person who's living in the house for 50 years isn't going to be paying 15 grand a year. They're going to be keeping their $1,000, $2,000 a year bill. Prop 13 is amazing because it keeps people in their house. As you retire and you go on Social Security, you're not paying these exorbitant bills. And it was applicable to secondary properties too, your rentals, any commercial buildings you have. It was a pretty neat thing. Now, the neatest thing about Proposition 13 was you could have left assets to your kids and not get reassessed. So you could leave your primary residence and you could have left up to $1 million of assessed value of other properties to your children. Which is a lot of property. Assessed value is a fraction of what the real value is. So a lot of your listeners today might be saying, well, how would this affect me? My parents died, back in the 90s, and we got all their properties and didn't get reassessed. We had Prop 13 then. So what happened was 2020 election rolls around. Proposition 19 is on the ballot in California. And essentially, Proposition 19, for lack of better terminology, extremely edited Proposition 13. It was kind of a poor marketing on how it got passed. And if it was all truthful and laid out transparently, I'm not sure it would pass today. But here's what Proposition 19 does, Bill. So now let's start with the secondary properties. If anybody's listening has a rental property, 2, 3, 4 rentals, if you have a commercial building, those automatically get reassessed when you die. Now, not for spouses. I'm talking when mom and dad both pass, but for children, grandchildren, nieces, nephews, whoever you want to leave it to, they will get reassessed with no planning. That's just the default. So if you have your trust and you've said, well, everything goes equal to my kids and I've been square for 20 years, I'm good, you're not good. And I'm going to talk about the consequences in a second. So that's a big major shift. All those properties get reassessed. And
let's just stop 1 second. Put a little context on this as a real estate agent. So sometimes when we look at public records, it has the payment of the tax amount. Like in my neighborhood, somebody who bought a house brand new for $2 million is going to pay about $20,000 a year in property taxes here to the city and county of Los Angeles, about 1% of the purchase price. The next door neighbor who bought the house in 1970, they're an elderly couple, because their house was bought back when houses were cheaper and only rose by inflation, because real estate has outstripped inflation. Real estate has been a great preservation of equity in the face of inflation. The same neighbor in the same house might be paying $600 a year instead of $20,000. If you get reassessed, you're going to start paying the $20,000 number because it's as though you bought the property new again. So that's why when you see those discrepancies, you go, how do these people avoid those taxes? That's what Josh is talking about, is when it comes time to pass on the property, we want to do it in a way that minimizes the taxes to the family.
Yeah.
Okay, I'm sorry, jump in.
No, I love it, Bill. And a real world example is myself and my neighbor. My neighbor, his grandparents originally owned the house. He's now the third generation owner. He's paying a couple of grand tops. With exact same floor plans next door to each other, and we're paying $8,500 a year. So reassessment or new owners, it's a significant jump. And if these jumps, Bill, were only one-time property tax, not the end of the world. We're talking about an extra $6, $8, $10, $15,000 every year forever until you die.
Right.
We're talking about six figures, maybe in some cases even seven figures,
right,
down the drain. So the big problem is for all these secondary properties and commercial properties are going to get reassessed. And I'll tell you, in almost every consultation I have, and after somebody's death and they have secondary properties, Bill, the children start crying because they thought these were our retirement plans. We thought we were going to, do everything mom and dad did, have a similar income stream. And now when I tell them, looking at the math, you really can't afford this, or it's right at that cusp of whether you should keep it.
Right.
Almost, I would even be so bold as to say we're at about 100%, but almost 100% of clients after death are now selling, because they have to. Just mathematically, it does not make sense.
Yeah. So
let me talk about the primary resident. That's going to affect almost every listener here. So the law does allow for the primary resident to not get reassessed. So how does that work? That only works if it was the primary house of mom or dad, and we're leaving that primary house to a child, and a child moves into that primary house and keeps it as their primary house within 1 year of mom or dad's death. So if you thought, well, mom's primary residence, I'm going to convert that to a rental, no dice. That will get reassessed because it's not going to be your primary residence. Now, if you think, well, that's good. I was expecting to move into mom's house, so I'm gonna save Prop 13. We have one more problem. What about your siblings? So, if mom's trust, which is more than 80% of the trust out there, mom or dad's trust will say, hey, I'm gonna leave it to my three kids equally and let them figure it out. Child one decides I want to keep this as the primary residence. We can save Prop 13, but where does child 2 and 3 get their 1/3 from? We have an issue, Bill, because the law says it has to be from a parent to a child. So if that child who moves into the house says, well, I'll just buy my siblings out, that's not a parent-child transaction. That's a sibling-sibling transaction. That gets reassessed, 2/3. If that child says, well, I'll get a loan on the property, that's how I'm going to solve it. Well, to get a loan, it has to be in your name as an individual. And you know what happens when we do that transfer? The assessor is going to say, hey, child one, good, you said it's your primary residence. Let me see the trust. Wait a minute. 3 ways. You guys didn't do it 3 ways. Where's the rest of the money? And so that's not going to work. So traditional loans, calling Wells Fargo or B of A, never going to happen.
Right.
That's not going to work. The only way to avoid that transaction or to help that transaction is you get an expensive what we call hard money loan to that trust after mom dies.
Right.
And we can talk about those problems, Bill, but real briefly, when you get a hard money loan to a trust, they expect you to pay back within about 6 months. Right. So you're going to be paying 10, 12, 15% interest to get a loan to the trust, to pay off your siblings, avoid reassessment. You think, great. 6 months later, now you're stressing because you better pay them off and you better find a traditional mortgage and qualify. There's a lot of moving parts and things can blow up in your face.
Yep.
So
you probably pay about 8 points to get that loan as well, right? So if you're borrowing $500,000, you can pay about $40,000 in loan fees, not to mention the other costs. It's expensive. In LA, I know you're based in Orange County. I'm sure you do business in LA and other counties as well. It seems to me that LA County assessor automatically reassesses every property and then makes you defend the case. Is that your experience? And do you see the same thing in other counties? Is that just a LA County thing?
Yeah, that's a good point, Bill. So it depends on the paperwork you're filing and if you get ahead of it. So, for example, If we just say, "Hey, mom died," and we tell the county that's it, and then we say, "Oh, we'll deal with the primary residence thing later," you bet you're going to get a reassessment immediately,
Yeah.
and then we're going to have to deal with it. Which dealing with it means paying a lawyer like myself, filing an appeal with the assessor, going through the motions, us winning, and then you get a reimbursement. Imagine getting a reimbursement from the government. It takes some time to do that.
Imagine that.
And meanwhile, you had to pay the bill, and they
Right.
don't give you interest on your money, by the way.
Right.
So you're right, Bill. It depends on the paperwork, though. So if we get ahead of things and we write to the assessor, don't reassess us, here's all the paperwork, we might be able to skip that automatic supplemental reassessment. Now, a quick note I'll mention, Bill, for your listeners is if they're in the situation where mom or dad passed and they're getting letters from the assessor, when you get a letter from the assessor that even mentions a supplemental, or it's going to be called a notice of supplemental assessment or notice of reassessment, anything where it's essentially, our bill's going to go up. If you want to appeal it, you need to appeal it and call a lawyer immediately. We generally only have 60 days to file the appeal from that letter.
Right.
That's not a lot of time to find a lawyer, interview them, pay a retainer, and the lawyer to do their job. That's not much time.
And I think that people are mistaken. They'll say, "Well, I don't want to get an attorney involved." On the regular part of the transaction, as a real estate agent, the escrow sends the preliminary change of ownership form. I think it's a state form, but certainly in LA, I think it's a state. It's the same in all the counties. But anyhow, and they'll call me and say, "Well, how should I fill it out?" I say, "Whoa. A, that's legal advice. B, this has big consequences potentially. It shouldn't. You should be able to fill out correctly." But the problem is, and I know I have customers who fill out correctly and they still get, it's almost as the county just ignores the form and just sees the transaction and assumes there's a reassessment due. That's my suspicion. Now I might be wrong. Don't mean to disparage anybody, but I've had customers and I had attorneys call me and say, "Hey, why did this happen? We sent the form in. Did your escrow send it incorrectly?" Yeah, all we had was the form you gave us. I believe the county just automatically, and think about it from the county's perspective, what a great cash flow tool, right? They get the new assessment and then they maybe later have to refund you money. They don't give you any penalty money. They don't send you a Starbucks card and a thank you letter. They just give you back the money they stole for 6 months after you paid your attorney's fees. So it's really important. And I always urge customers, your attorney might charge you for an hour to review this. And I don't know, $300, $600, whatever the fee is. It's burned $20,000 reassessment fee and battling that for 6 months. And believe me, attorneys going to charge more than that to hire him to fight the reassessment fee.
You're absolutely right, Bill. And so often I do notice, because we hire clients for what is called a trust administration, or in the probate. We have our clients. And then they'll go and sell a property and tell us after the fact, "By the way, we closed and the money's in the account. Why didn't you tell us?" So I would encourage your listeners, if they have an attorney, keep them in the loop, tell them what's going on with escrow, show them the paperwork. You're paying the attorney good money. Excuse me, Bill. So you're paying the attorney good money. Use them. You're absolutely right. An extra couple hours of review, or even, it doesn't even take that long. Heck of a lot better than an appeal.
Ounce of prevention rather than a pound of cure is definitely. Hey, let me just take a quick minute here to kind of do some quick housekeeping. This is Probate Weekly. We do this every week, and when new episodes come out, we also have a Facebook group to continue the conversation, as well as where we post the content. If you have probate-related or estate planning-related content, love to have you post it there. We have our past episodes, but also friends of the program post their episodes as well and their content. Love to have you do that. If you remember, probateweekly.com is where you find it. You can sign up for email reminders. If you want text reminders, feel free to put your phone number in. You don't have to. We don't require that. You can scroll down and find us on other audio formats, Spotify and Apple Podcasts and all that stuff. And then past episodes are on YouTube right there. Our guest today, really excited to have, again, a friend of the program, Joshua Ramirez, who's an attorney in Yorba Linda. I grew up in La Habra, which is near Yorba Linda, Placentia, and Brea. To me, they're all kind of the same. They're not La Habra, but they're La Habra-ish. So I'm sorry, you're in Yorba Linda, correct?
Correct.
Yeah. So Yorba Linda, California. And by the way, my high school girlfriends live in Yorba Linda, so I know the area pretty well. Who's an estate planning attorney. And you can go to California Estateplanningservices.com is a website. On there's a phone number. You also can scroll down and get more information about him as a company and hit the contact button to contact him as well. So a really great guy and based in Orange County, but also familiar with Southern California as a whole. Let's talk a bit about, this is a new phenomenon coming up at us, I think, that we're going to see a lot of, which is estate planning as it relates to fires. I know Orange County, you had your share of fires a couple of years ago, but I'm sure you have clients who are also in the Indian Hills fires as well as West LA, with people who passed, they had the property, they didn't really probate it, and all of a sudden now they have an insurance claim. Seems to me it's really important to jump on that insurance claim right away on behalf of the state. You might have said, well, we're not in a hurry to sell the house, but it seems to me that if you don't get the front line of insurance payouts, you might miss out on the opportunity. What are you advising clients? Are you getting much? Do you service that area and do you get much questions as far as insurance claims?
Yeah, I do, and we've had a couple clients whose house unfortunately burned in Altadena. So what I'll start with is the insurance. Let me start with insurance and mortgage issues. So a lot of the times clients say, well, Josh, mom passed, dad passed, or I inherited it from my brother, sister. I don't want to tell the mortgage company. I don't want to get the new rates. I totally get it. I don't want you to jump from 2.8% to 6.2% either. Totally get it. But when you don't take care of that, it is absolutely possible to take care of your other insurances, but it's generally all in one basket. You need to take care of everything because it's your mortgage company sometimes is paying for the homeowner's insurance and is requiring it. So sometimes the answer is do it right. Be careful for the listeners who are basically still have it in a deceased person's name. Be very, very cautious because you can get burned, no pun intended, very, very easily. So now with homeowners insurance, I have not. Here's the concern, Bill. The concern is you moved your property into a trust. This is the number one concern I hear. And the house burns down, but you never called your homeowner's insurance and told them. So it's still in John and Jane Doe as individuals.
Yeah.
Not in the John and Jane Doe living trust. I've never heard of an insurance company denying the claim, but the concern is that they could.
Right.
In order to truly evaluate if they could deny your claim, we have to read your homeowner's insurance policy. But let's go down that path. That the insurance company is big, bad, evil, and they want to try to deny it because you have a trust. So for my entire practice, I've always told my clients when we sign a trust, call your homeowner's insurance or your insurance broker, let them know what they're doing. 8 out of 10 times, they'll say, thank you, Mrs. Smith, for calling us. We typed it out. It's now an additional insured. We're all done. 2 out of 10 times do they say, ooh, we got to get you a new policy. Very, very rare. And I think maybe once or twice in my career have they absolutely said, oh, thanks, you wouldn't have been covered. I can recall maybe once. So I've always advised my clients at the beginning of my career, tell your homeowner's insurance policy. It's funny because these fires have started a debate amongst lawyers. And for people who already have estate planning attorneys, you might see their newsletters coming out, an email telling you to do this. I'm quite frankly shocked that this has not been common practice.
Can you stop right there? Because I think, again, because you're deep in this, and I think I deal every day with people who are caught unaware. I think you're 100% right that why would you not contact the insurance company? What does it cost you? Nothing. Maybe they change the policy. Now, my experience, never. My experience is it's just an additional insured. There's a piece of paper that they need to generate. You have it. You're done with it. I've never personally seen a person pay a premium or deny coverage because they look at it as a person that really owns it and such. But why would you give them the chance to raise the issue by not doing the paperwork? And I think that when attorneys give you this advice in estate planning, that's the difference between self-help and listening to a professional. All Josh is saying is it doesn't cost anything to take that complaint off the table. And I'm going to say to you, not as an attorney, but as a businessman, I believe some of these insurance companies are going to go broke. And before they go broke, they'll do anything to stay in business. I saw this in the mortgage business. I saw the B of A and Wells Fargo. You should know that today, the B of A we have is not B of A. It was a company that bought the name because Bank of America went broke. Wells Fargo went broke. They were bought by Wachovia. Chase is not really Chase. They were bought by one of those companies. Before they go broke, they're going to deny everything. And they're going to make you fight them. They're going to make you hire an attorney. They're going to make you pay. And when your attorney like Josh says something, you might go, well, what's the big deal? It says my name on there. Okay, it's not a big deal unless it's a big deal. And if it's your insurance company is going broke and they delay things for 6 months and then they run out of money and you're too late to get a penny from them, that's why you hired the insurance. Okay, the attorney. Okay, Josh, sorry about that, but I just want to advise my customers. Pay attention to the attorney. Just do what the attorney says and shut up. I'm sorry. Did I say that?
And I'll tell you, Bill. So one thing I'll comment, and I'll tread carefully when I say this, but if you went through your trust attorney and you never heard that advice, that concerns me.
Yes.
Now, if your attorney gave you the advice and you just didn't do it, can't help you. But
yes.
But
well, hold on. I'm going to admonish you. You're an idiot. You hire the attorney. You paid him good money. If you don't trust him, get another one. If you trust him or her, do what they tell you to do. There's one quarterback on the team. They call the play, run the play. If you don't trust them, fire them, get somebody else, and do what they say. So I would say, no, it's not okay not to do what the attorney says. And you're 100% right. If they did not tell you to do this, that concerns me. What else do they have to do but try to limit your risks? I'm sorry. I'm just on a soapbox in this issue.
No, I love it, Bill. And you don't pay. Clients don't pay us. I mean, you might think, well, I'm hiring the attorney and getting my trust book together. Great. You're not paying us for those pieces of paper and to transfer real estate. That's easy. And most attorneys can do that. And there's even self-help ways you can do that. You're paying us for what's in here and the advice and everything that you don't know. Very easy. The reason there's a lot of older estate planning attorneys out there is they think it's easy. I've been doing corporate work for 20 years. I can put down that it goes to the kids equally on a sheet of paper. That's easy. Right. And it is. That part is extremely simple. It's all the tax things and the insurance things surrounding it that why you need an experienced estate planning attorney.
Yeah. It's never a problem until it's a problem. Then it's a problem.
That's it, bro.
So one of the things that, in estate, if we, go to estate planning a little bit, we talked about, notifying insurance and how to work with the mortgage companies. And all these are really customized answers. I mean, I appreciate Josh, you're giving us some great general overview advice, but the reality is if you have these questions, you should be talking to your attorney as applies to you specifically. One of the challenges, on one hand, I want to encourage all my customers who buy property or own property to get a proper plan, get an appropriate plan, review it, implement it, follow up on it. As a professional, I encourage people, refer people to attorneys. This is why I do this podcast. Sometimes I feel like I want to push them to get the job done. Like I want to follow up and say, hey, did you transfer the titles of your bank accounts into the trust? I can check online and see if the real estate was done. That's always a clue if the real estate's not transferred. Some attorneys do it, some don't do it, but it's got to get done one way or the other. What are the best practices for professionals that refer you business, whether it be a real estate agent or some other financial professional? What are some of the best practices that help us work together to get our customers to take the actions and follow through and get things done?
Yeah, I think first and foremost is sharing and understanding the client's goals. Make sure we all know what is the purpose of Bill and Josh being involved with Mrs. Smith. What are we doing here? Are we selling? Are we buying? Is she passing away soon? Are we worried about a lawsuit? What is our number one goal? Once we understand the client goal, then it's an exchange of information. That's how we protect our client and work together. It's instead of an email, hey, Bill, by the way, I did her trust and I moved all the real estate. It's, hey, Bill, this is what I'm going to do for Mrs. Smith. What do you think before I proceed? And vice versa. Before you sell the property or take it out of her trust to help her get a loan. Hey, Josh, is that going to hurt Prop 13 or her kids or what are we doing here? So that exchange of information, Bill, is huge.
So were you on following up with customers and they come, they meet with you, you put the plan together. Do you follow up with them as far as the transfer of real estate? Do you follow up with it? Do you provide them with electronic versions of it as one keep a copy, or do you expect them to keep copy? Talk about the post, the end and the post process a little bit.
Yeah. So let me talk about you've signed your trust and now what? And I'll preface this, Bill, with not tooting my own horn. We're not special. So if your experience who are listening is below this, what we do is the very good standard of care. I have concerns if this is all new to people. So after you sign your big book, your nice fancy book with your lawyer, you got to move assets into it. So the lawyer should be taking care of real estate. So the lawyer should be able to transfer your real estate into your trust in any state they're licensed in. So for example, we're licensed in California and Washington. We can take care of those states. You have Florida property. We're not licensed in Florida, so we need to do that. So then the next step is your lawyer should take point on making sure the rest gets transferred, the rest of the real estate. So what does that mean? Well, it means either hounding you, making sure you called the lawyer in Florida and transferred it and paid them an extra $400 or $500 and did the deed, or we found a company that does it. That there are non-lawyer companies that transfer real estate nationwide, but it's making sure that real estate gets transferred. And to be honest, though, sometimes it's a matter of cost. Clients don't want to pay us to find a lawyer out of state and make sure it's done right, and I get it. So in that case, I tell the client, well, then you better make sure you're on it.
It better get done. Now, I don't think other states are as onerous as California in general. There are other, states that take certificates and affidavits and different processes. But why would you play around with a piece of real estate? They hired you. Why would they not just do what you tell them to do?
It's mind-boggling sometimes. I have a client that I'm thinking in my mind right now that it's been a couple of years, and did you fund your Georgia property? Well, not yet. I'm getting around to it. You paid good money for 90% of the plan now. Finish it off. Right. So now it's real estate. Real estate, pretty cut and dry. Somebody's got to fund it, preferably a lawyer. And I'll also preface this, so sorry to throw all my lawyer friends under the bus nationwide here, but
go ahead.
When you have your Florida property and you say, okay, let me move it to my California trust, which is okay to do. You go through a lawyer or you go through a company. Company might be $50 to $100 cheaper, to be very honest. But if that company messes anything up and your kids have to go have a probate issue, they're paying for it.
Right.
You got malpractice.
Right.
So hire a local law firm to do your deed in any state you're going to do, similar in the general county where you have your property.
Yeah. That's good advice. I'm the broker for a state that left $40 million of assets. He met with a estate planner. He had the book at his house for about 2 years. They've been taught, and then we talk about from time to time. And I get, the attorney, you can't make the customer execute the plan. The customer paid for most of the money, right? Whatever the fee was, I think 80% of it he paid for. The attorney is heartbroken because she says, I would call every 90 days and push him. And, I get it. Now, we're all in results-oriented businesses if you're a business owner. And to some degree, it is kind of her responsibility that he didn't. And she should say, what can I do next time to get the customer to execute? And those of you watching, if you're a consumer who needs to do an estate plan, get it done. And if you're a professional, what can we do to help our customers execute that plan and get it done? Because it's no good just sitting in the notebook. You actually have to put the assets in. It's the number one plan. So you also do trust litigation. Is that litigation that you do to defend clients that you've done plans for, or do you do litigation for clients that maybe didn't get it done properly and need some help after the fact? How does the mix of your litigation work?
Yeah, in fact, one of my largest practice areas, I would say if there's three, it's the trust and estate litigation, estate planning, and property tax planning, which is why I like talking about Prop 13, which we might touch upon in a few minutes here again. How do we avoid the reassessment? But in trust litigation, Bill, the cases really come down to two major cases. One is somebody changed an estate plan when it shouldn't have been changed. Mrs. Smith did not have capacity. The son who hadn't seen her for 20 years all of a sudden got everything. So those typically surround claims of undue influence, lack of capacity, elder abuse. So those cases are something we pursue very, very often. Occasionally we'll defend them. If it was a legitimate plan and a son who hadn't seen her for 20 years is saying I should have inherited, we'll defend plans also. So that elder abuse arena is one major case. The second and most common case is surrounds sibling disputes. It's generally a bad trustee. So we're either suing a bad trustee because they're not doing what they're supposed to do. Generally, they're living in the house. They haven't sold mom's house. They're living there rent free. They haven't provided an accounting. We have 50 years since mom died. We need to get on it. Suing trustees. And then the flip side of the coin, sometimes the trustee just didn't know the law fully. And so we're defending trustees to try to either make things right or explain why what the trustee did was right. So those are the big major disputes: elder abuse and trustee sibling disputes.
So let's talk about, I think the one you mentioned is certainly a classic that I deal with as a real estate agent, which is, a sister calls me and says, hey, there's three of us and the brothers moved in the house when mom and dad were at the tail end. He's been living there for free, just like you said, 3 years. That's kind of a standard number. Not paying rent. Maybe he's paying a mortgage of $40,000 on an $800,000 house. Maybe he's paying the property taxes and insurance, nominal costs compared to what a lease would be. Certainly not helping the other siblings who are entitled to the property. How do you get them out? Sometimes you have to evict them. Though the truth is, I think that any eviction costs would come out of their heirship if you can get down to that point with it. It just seems to me that you can talk and talk and talk to that sibling. They're never going to leave ever until they're forced out. Like they'll tell you, okay, I'll another month, another 6 months. Well, just another 6 months. But if you've been living your whole life for free, most of those people don't have the physical ability to pay the rent if they had to move out. There's no alternative for them. So how do those, when you have the sister, let's say, and the brother's living in the house, how does that end up? What's that litigation? Yeah. Obviously, most litigation ends up settled. How does that scenario play itself out?
Yeah, two big cases. So if we're in charge, the client who hires us is the trustee and the brother just hadn't moved, that's very simple. You just call it, we refer you to an eviction attorney. We start the eviction process. And then usually if we get attorney's fees in that case, then we'll just deduct it from that sibling share when we do an accounting after the house sells. So in some respects, it's a little bit easier legally when we're in charge. Not a little bit, a lot of bit easier when we're in charge, or our client's in charge as trustee or executor. But it's the emotions that stop us from going full steam ahead. Right. Sister says, but he's been down on his luck, or but he just got released out of prison 2 years ago. But there's always excuses until there's a big flood that cost $30,000 in the house because he was negligent and he had his buddies partying with him. Until his girlfriend came into the house and slipped and fell and is now suing the estate because the floor was negligently maintained. Until. So I unfortunately have to tell my clients we have to take emotions out of it. He'll get his portion when everything sells, but we're not his mom. We're not his dad. He's made his life choices. He's got to figure out how to be an adult from here.
That's a tough one. That's a tough one to tell.
Very tough. And some clients are like gung-ho about it. Let's kick him out. And some are still wishy-washy. And a lot of clients call me and say, I don't really want to do this because I have a house and I'm secure, but my siblings are making me. Well, sometimes then don't be the trustee. If you can't follow through on the documents, resign. If you don't have the heart to do what's right, resign. And clients don't like to resign. They like to have their cake and eat it too. They want to be in charge and call the shots, but not really call any shots. And that's not how to work. Now, the flip side, the other kind of case, Bill, is when the brother who's living in the house is not living, he's the trustee. That's hard because now we can't just go and evict because he's in control. Right. So first, before we go to eviction, we have to remove him as trustee. That's called a breach of fiduciary duty. So we have to convince a judge why he's a bad trustee, to kick him out. Once we get control of trustee, then we start that process. Unfortunately, kicking him out as trustee, that could take 1.5 to 2 years of litigation. He might not resign easily. He's going to go kicking and screaming all the way to a trial.
And the clients come to you assume, well, he's a bad guy. It should happen right away. And the answer is, you say he's a bad guy, and he might be, but the court needs to prove he's a bad guy because the decedent thought he was a good enough guy to make him the trustee. And the judge is always going to give that decedent's written instructions a lot of weight before they throw somebody off the case, so to speak. And so I think sometimes the expectations are on that. Just because you're right doesn't mean you win in law in court, or it might mean you win, but it might take you years and a lot of money.
There's no truer statement than the wheels of justice turn slowly. I mean, right now in LA County, Orange County, Riverside and San Bernardino are slightly faster, but LA and Orange County, from the time you hire us to the time we get to trial, is going to be somewhere around 1.5 to 2 years. So if you're thinking, well, my brother's never going to get out and he's in charge, don't wait a year and see what happens, because then start the clock. Let's just start the clock. And when you mentioned settlement, Bill, we're going to try to settle. My goal is not to take your family to trial and break you up forever. I don't want your family broken up. My goal is maybe we offer him an extra 10 grand. Not morally right, but it might be financially wise. Offer him 10 grand to move out, resign, help him get a new place so we can sell it and give him the rest. That's kind of called the cash for keys. It's done very often in real estate transactions. So we look for ways that, what's going to be cheaper for the family. Paying the dad brother a little bit more, better than paying the lawyer for 2 years. That.
I tell customers, I'll give them legal advice, but from a business perspective, if you go to trial to remove a trustee, you better be prepared to spend about $100,000. Now, that can come out of the equity of the house. There's different ways to finance it, but you better have enough equity where it's clear your share. If there's three of you, it would have to be $300,000 or $400,000. You have to have like $1 million property that we're talking about to make sense. And if you don't have that much, and if he puts up a fight and he has money, it's going to cost more and take longer. And that's just unfortunately how that process works.
It's very wise, Bill. And in my initial consultations, which by the way are always free, so anybody wants to call me, we talk on the phone for free or via Zoom. Let's just chat. But in our initial consultation for any litigated matter, I go straight to money towards the end of that call. And what is it going to cost? What's the reward? So if your brother stole 20 grand from you, I'm going to tell you, let it go. I'm guaranteed going to tell you to let it go. And that sucks. Now, another lawyer might say, screw him, let's go all the way, which legally is right. That's fine. But again, it's not just legal answers. There's the legal side, the financial side, the moral side, your stress, heartache, and overarching all this is family dynamics. Because once you file that lawsuit, your family will never be the same.
I give business advice. I'll say you can call an attorney and litigate it, for $20,000. I would also advise people to let it go. And then I'll send them a link to the theme song from ICE, Let It Go. And I say, just play the song and sing it a few times, and it'll help you let it go. Because it's just, you're not going to get $20,000 back legally. It's just, it's just not going to happen. It's just not, it's too difficult. It's not a small claims matter. It's a probate matter. And so it causes too much difficulty to get what you want, unfortunately.
Yeah. So Bill, if you don't mind, what I'd like to towards the end of this cast right now is kind of talk about what do we do about Prop 13? In the beginning, I kind of mentioned all the problems. Yeah. So I like to shift for a couple minutes. So we mentioned the problems. You're going to get reassessed. Your bill's going from $2 grand to 20 grand. It's just not practical for rentals anymore. There is a way to avoid reassessment. So I'm going to start with even in lawyer circles. I'm on an email chain where there's several, dozens and dozens, if not 100 lawyers. And even lawyers disagree if you can do it or not. But I'm going to tell your listeners right now, Bill, we can avoid reassessments for families before mom and dad die. It's the key. Once mom or dad dies, we're stuck. But before mom and dad die, we can avoid reassessment. Our firm has a 100% success rate in avoiding the reassessment.
Oh, wow.
So I'm not saying this is a guaranteed result, but I am saying I've never lost this kind of case since Prop 13 or Prop 19 happened in 2020. So from 2021 to current, 100% success rate. If we wanted to avoid reassessment, some of the I guess conditions. The first thing is the parent has to be fully cognizant, aware of what they're doing, or have a power of attorney in place. If your parent is now incapacitated, we're not taking property rights away from them. It's too late. So you have to know what you're doing. Second thing is your parent has to survive for 2 years. These kinds of plans to avoid reassessment can take a couple of years to complete. So you can't call me when dad's on his deathbed. That's probably not going to work. Now, still call me. There's some things we can do to save some of the bill, but we won't save it all. So 2 years surviving. Your parent, or if you're living, or if you're listening right now and it's your property you want to give to your kids, you have to be willing to give up control. That means, and it's not this simple, so don't do a deed, please. That's not what I'm saying. But that means you're going to give up rights to your property. You're going to give up the income for your property if you have rentals. You have to be willing to give up control in favor of your kids. And I also need to know from the children that they do intend to keep this property for years and years and years to come. If we're just being coy about it and don't want to tell mom, but we're selling this house after the year after she dies, we do not do a Proposition 19 plan to avoid reassessment. You just inherit it because there's property taxes, there's capital gains taxes, there's different taxes we need to balance. So, but if a client fits into those categories, I'm willing to give up control. My kids are going to keep this forever. I'm pretty healthy. Let's talk. And then the answer is let's talk, because like I say, I will avoid property tax reassessment for your family. And I've done this in LA, Orange, Riverside, San Bernardino. So anywhere in Southern California, you have this issue, even in Northern California, we can help.
It's particularly big now in the city of LA, where we have a 5% surcharge on houses over 5 million and change, and I think a 10% for over 10 million or whatever the numbers are. So there are many families in those categories that have found ways to hold those properties for a long time, keep them in the family, keep them multi-generational, maybe put multiple families in a large house and keep and avoid the taxes. And others have turned them into rental income down the road. And so there's, you have to be able to afford to keep the property and then be able to transfer it into rental. So that's, again, part of the plan, and talk to Josh if that's something you're interested in doing. But I just see more and more that proper planning is becoming more and more important as the city and the county and state are trying to get more of that equity, and the more you can hold on to, the more valuable it is. So
That's
definitely
right.
now.
I chuckle now. We hired a new associate, so as I've been training her, one of the things we talk about is, well, before Prop 19, if somebody would call for an estate plan, kind of easy. What do you need to do? What are your kids' names? Here's the cost, and
Right.
9 times out of 10 people move forward because we don't price gouge people, and we're pretty easy to deal with. Nowadays, when people call me for an estate plan and they have no clue about Proposition 19 and I educate them, our initial retainer rate is almost at zero, because in that initial meeting, people say, and pardon my French, but shoot, Josh, I did not know this. I do need to talk to my kids, and let's set a follow up in a few weeks. They're very, very grateful, and some people coming back and say they're just going to inherit it and they'll sell it. And some people say, let's talk how to avoid it. The people who have hired us to avoid reassessment are all happy. We've avoided it quite often.
Nice.
And the people who don't, I think if you wanted to keep the property after your parent dies, you're going to regret not going down this path. But It's not up to us who is inheriting it. So I want to make that very clear. It is up to mom and dad. Their word goes.
Right. Very good. Well, look, Josh, I know there's a whole world we can continue to talk about, and I appreciate, and we're going to have you back, I think, on our other podcast, Estate Planning. But more than that, for anybody who's watching or listening to this, you can reach out to him, local attorney in Yorba Linda, California. CaliforniaEstatePlanningServices.com is the website, and the phone number is 714-584-5009. You can call there. Set up, as he mentioned, free consultation and focus on estate planning, trust litigation, conservatorships, probate, and related entities. Josh, always great to have you on the call. Thanks for all your information today. I really appreciate it.
Thank you, Bill.
And for the rest of you, this is probateweekly.com. We get together every week and talk about probate-related issues and estate planning issues. You go to probateweekly.com. You can register if you want reminders. If you want text reminders, you don't need to, but you can also do that. And then scroll down. You can get us on audio formats, past episodes on YouTube as well. I'm at Bill Gross Probate or probateweekly.com. Thank you for your support, and we'll talk to you soon. Bye-bye.